We already talked about the basis of why compensation makes sense for in a negligence situation. We're compensating if it seems fair once we focus on the victim to have somebody else pay for what happened to the victim, right? Another way to put it, is it fair that the injured person be stuck with the consequence? Should we try to shift the consequences to somebody else, make them pay for what happened rather than the person who suffered what happened? Now, what this can mean is that the evil doing of the person who we're trying to sue is less important, right? Unlike criminal law where we're looking to punish, we're not necessarily looking to punish. We're just trying to say, well, it makes more sense to hold you responsible than the person who suffered the consequences. And as long as that's the case, we're okay with having them foot the bill. Who is the least unfair person to have pay for this? Another way of phrasing the same question. It's not that we hate you. It's not that we want to punish you, put you in jail. We just want to say, look, as it's just more fair to have you pay for what happened than the person who happened to suffer the injury. Now, what this can lead to is focusing on this question in a way also sort of in a grander social way of saying, the way that we frame this law is also going to have a consequence in that we want to encourage people to act carefully, right? At least carefully enough that people won't get injured because of the way that they're acting. And so we say to ourselves, the way that we apportion blame here by forcing people to pay out, we want to shape society in a way so that we encourage people to act in the right way. And sometimes what that can mean, this is where the stuff we're looking at today kicks in, sometimes that can mean focusing not on maybe the person who's difficult, but on somebody who we want to encourage to control the dangerous person. And in case you hadn't anticipated where this is going, this is where we get to the first major category of vicarious liability. That is where we want to focus on getting parents to control dangerous children. Okay, so this is Article 1459 of the Civil Code. It starts like this. A person having parental authority, this fancy way of just saying a parent, is bound to make reparation for injury caused to another, that's just saying has to pay, by the act or fault of the minor under his authority. Okay, so all it's saying is a parent's got to pay for what their kid has done when the kid is acting in a faulty way, unless he proves, and that's the parent, it always says he, it never says she in the Civil Code, but it means he, unless he proves that he himself did not commit any fault. Okay, so it's saying the parent's got to pay for what the kid did if the kid screwed up, unless the parent can show that he didn't screw up. If your kid screws up, you've got to pay for it unless you can prove to the court, not that they prove that you did something wrong, but you prove to the court, you convince them, I didn't do anything wrong concerning how I kept an eye on my kids or on how I educated them, right? So let's figure out how this works. The victim takes you to court, sues you, and says, okay, I'm going to prove that this person, this 12-year-old, is under 18, that they're actually your kid, and that they were at fault. They acted negligently. Now, normally, if somebody's at fault, causes injury to me, I can only sue that person. All that 1459 does is says, yeah, you can sue the kid for being faulty and for causing injury, but if you also want to sue the parents, if you also want to be able to seize the parents' property or whatever it is, then you've also got to prove that this kid is a minor, is under 18, and is the child of the person you're also suing. Okay? And once you do that, it doesn't mean you automatically win, but then it comes to the parent to prove that as a parent, this person did everything to raise the child right. And it becomes their job to prove, they've got the burden of proof, the burden of showing that they've actually been a good parent here. Okay, so let's go over that again. You're always allowed to sue somebody for doing something negligent that causes you injury. But the problem is, if you're just going to sue a kid, and all the kid's got is a piggy bank with $7.38 in it, then there's no real point in suing the kid, right? And the kid, you could just sue the kid, and then your judgment works against them for 10 years. And when the kid turns 23, they just say, well, now I'm going to start earning some money because I've graduated from school. At that point, you can no longer collect money from the kid, right? So it's very important for victims to be able to try and go after the parents as well, because practically speaking, the parents are more likely to have some source of income to be able to pay off the damage. And if you want to go after that parent, this is what you have to prove. Then it's up to the parent to try and convince the judge, yes, I know this awful kid was my kid. Yes, I know that they're under 18. Yes, I know they did something stupid and caused injury. But listen, Miss Judge, Mr. Judge, I'm going to explain to you that I was actually really good as a parent. I looked after this kid, and I tried to keep an eye on him. It just happens he was so terrible that despite all my good efforts, they still did bad stuff. Okay, let's see an example. This is a case from, I think, the 1960s in Quebec. It's quite an old case called Gin versus Sisson. So the story was there was a 6-year-old kid, and he, along with some of his friends, was throwing rocks at this girl. And one rock, it's not clear if he threw the rock, but for other legal principles, that's not really that important. But one of the kids in this crowd threw a rock that hit this girl in the face, causing her serious injury. She was partially disfigured by it, needed some surgery, scarred, all this stuff. And the kid definitely was in this pack of kids throwing the rocks and is definitely faulty to be throwing the rocks. And throwing the rocks definitely caused the injury. Again, the issue of whether he was the one who threw the rock or not, that's a whole cause issue that we won't go into. Now, because all this is proven, it's proven that this was this guy's kid, that means the dad is now presumed liable under 1459 of the Civil Code. That's the article we were just looking at. What the dad then had to prove was that he had done as much as he could to show the kid that this isn't the way that he should be working. He hadn't been negligent in supervising the kid, and he tried to convince the court, look, I raised this kid right. The fact that he did this was contrary to everything I taught him. So the court in this case, the Quebec court, believed the dad, that the son actually knew that if his parents had found out about what he was doing, throwing the rocks and all this, that he would have been punished for throwing the rock. And based on the fact that the court accepted this, that the kid knew that he wasn't supposed to be doing what he was doing, he knew he would get punished if they found out, the judge decided, yeah, the son is liable under 1457. You can sue the 6-year-old. Good luck with that because he doesn't have any money. But you cannot sue the parents because they did their job as parents. They convinced the court that they had raised the child to know right from wrong here. And so this is how the article works. It's still, the parent can still get out from under it. They can convince the judge, yeah, I know it was terrible what my stupid son did, but really, I did everything I could, so I should not be held responsible.